I know we've talked a lot about litigation, how you get involved with litigation when things go south, things end up being a failure, or someone's angry with the other party and they decide to file a lawsuit. That's where you often get involved. But you also get involved earlier in the process as well, don't you? Like, I mean, in other words, is it too early to hire someone like you to, especially if you don't have a super sophisticated internal general counsel, or your general counsel is probably likely not used to dealing with these sorts of contracts and these sorts of nuances you're talking about? But is that something that people listening here today can do? Can they hire someone like you to take a look at the contracts and give them advice more from a legal and risk mitigation perspective?
I think you need to get your attorneys involved way sooner than you actually think that you need to get them involved. There's an old saying in my industry, it's early legal advice is not expensive. Okay.
Right.
It's late legal advice that is incredibly expensive. So if you get your attorney involved, he's looking at your RFI, your RFP, he's looking at your requirements for the software. He's involved in the software selection process to some extent. That should help you. And it's going to have the overall effect of mitigating the likelihood of a failure down the road, because they should be able to kind of see this from an objective standpoint and cut through the BS of the vendors